Hello and welcome to the 9 St John Street webinar on Swift and Carpenter. We're also recording this as a podcast, and so if you're listening to this without sight of us, then you're welcome too. I'm joined today by Brian McCluggage and Chris Kennedy QC, who are going to be discussing the ramifications, both legal and practical, for accommodation claims following this long-awaited judgment. The focus on today's webinar will be the significance of Swift for defendants. We will be recording a separate webinar focusing on claimants. For those that may not be familiar with the facts of this case, it involved a lady who suffered severe bilateral lower limb injuries, including a transtibial amputation to her left leg and significant fractures to her right foot. She was 39 at the time of the accident and 43 at the time of trial. She required single-storey accommodation and claimed for the costs of purchasing this accommodation. Her claim for the costs of purchasing the accommodation was at first instance rejected. This was because the existing case law following Roberts and Johnston required the calculation of the capital sum to purchase the property to be calculated by reference to the prevailing discount rate, and in the case of a negative discount rate, she would not be deemed to suffer any loss. Clearly, however, the need to purchase single-storey accommodation was going to cost an additional sum, and Mrs. Justice Lambert, the judge at first instance, granted permission to the Court of Appeal to consider the matter further. This was a somewhat novel appeal in which the Court of Appeal heard evidence specific to the issue of accommodation. Evidence was adduced, both oral and written, from a number of experts, including economists, actuaries, a financial advisor, and a surveyor. The Court of Appeal held, firstly, they were not bound by Roberts and Johnston. Secondly, in the context of modern property prices and a negative discount rate, Roberts and Johnston no longer achieves fair and reasonable compensation because it produces a nil result. Thirdly, the best method to achieve certainty, clarity, and most importantly, to meet the need for fair and reasonable compensation whilst avoiding a windfall of retaining the entire value of the property was to award the full capital value of the incremental sum required to purchase the accommodation, but to reduce this sum by the value of the notional reversionary interest based on the existing market value of the property. This was to avoid a windfall to the claimant. The rate at which the reversionary interest is to be calculated is 5%, which was described as a cautious benchmark. There is therefore now a new legal basis and arithmetical formula for calculating the cost of accommodation claims. I'm now going to hand over to Brian, who is going to explain in more detail some of the legal and economic concepts discussed in Swift and to provide you with practical assistance on how to apply the formula to existing claims.
Well, thank you, Matthew. I'm lucky enough to be able to speak to you about mathematics and arithmetic. In other words, the calculation part of Swift and Carpenter. And I suppose the starting point is for me to observe that the claimant at first instance put forward 4 different solutions, which in the end were none of those chosen by the Court of Appeal, who, after hearing evidence from financial advisors, actuaries, and economists, decided to allow claimants damages equating to the net purchase price of a property minus the value of a reversionary interest. And what I'm going to do is to try and explain what a reversionary interest is and how the calculation is performed because whether or not we think it's right, and I would submit the decision is questionable in various respects, nonetheless, it's the one that we're going to have to apply in the vast majority of cases, unless, of course, there's a further appeal. Now, the calculation, although somewhat intimidating at first, is in fact fairly straightforward once you know how to do it. And it seems plain to me that the Court of Appeal wanted a straightforward calculation, because Lord Justice Irwin emphasised at paragraph 78 of his judgment that in personal injury work, as he puts it, perhaps more than in any other field of litigation, disputes are resolved by negotiation and settlement. There is the strongest possible need for clear guidance from courts as to how to fairly approach such negotiations. Both claimants and insurers, as he put it, have a strong interest in predictability, which brings resolution and some containment of costs. Well, of course, if we know what the principle is, then inevitably it's easier to settle a case, rather than, as parties have been doing in the past year, speculating in their schedules and counter schedules of loss as to what the Court of Appeal might say. So I'm going to look at it mathematically, but first saying just a couple of words about what the calculation is actually trying to do, because it does strike me that we're probably going to be better lawyers, better able to explain it to our clients if we understand what the rationale of the calculation is. It did strike me as I was preparing for this talk that there are a great many lawyers who've been doing Roberts and Johnson calculations for almost 30 years and possibly don't actually know what the Roberts and Johnson calculation was designed to reflect, which is, of course, the cost of capital or lost opportunity cost in the money invested in a house, rather than the cost of the house itself. Well, when we're looking at the calculation and working out what it represents, really what the court was trying to do was allow the claimant enough money to purchase the house while providing for an offset to try and reflect that there was almost certainly a windfall element to the damages awarded. And the reason why there's a windfall is that a house is a capital asset which generally tends to appreciate over time. People say property always goes up. Well, history shows property does go up, albeit not in a straight line, as anybody who purchased a house in, say, 2006, 2007 knows very well. That would be contrasted with purchasing a depreciating asset, such as a motor vehicle, which, as we all know, loses value over time. Well, how are the Court of Appeal going to deal with this? The defendant's arguments were very substantially on the appeal that because the house appreciates in value, it was unfair to begin as a starting point with the capital cost of buying the house itself. That didn't meet success, obviously, and the reasons why is something Chris Kennedy will talk about in more detail. But the court decided that the fairest way to deal with the windfall issue was to value a reversionary interest in the property. Now, what's a reversionary interest when it comes knocking at your door? As personal injury, clinical negligence lawyers, not something we deal with in our day-to-day practice, something more that certain types of chancery lawyer would be used to. Well, a reversionary interest, in its very simplest of terms, is an interest that's finite, usually in time, in real property. And one would see it often if a property owner was creating a trust over a house, for example. So let's assume that Sam, the property owner, wants to create a trust to benefit his two children, Maureen and Sue. Sam would create a trust, let's say, for Maureen's life because of family circumstances. Whenever Maureen dies, then the residuary interest in the property will go to the other daughter, Sue. So they're both beneficiaries, but Maureen's really the main beneficiary because she's going to take control of the property now, whereas Sue is what the lawyers used to call the remainder man, or remainder woman in this case. And in some ways, what we're trying to do in Swift and Carpenter is value what Sue's interest would be when she takes the property after what could be 10, 20, 50 years of Maureen's life. But until the end of Maureen's life, Sue doesn't have a right to the property. Now, as it turns out, these reversionary interests, sometimes in domestic property, more often perhaps in commercial property or in shares and the like that have been given as a life interest under a trust to someone, do have a market value. And so Sue, who's not going to get her property until 10, 20, 50 years' time, might decide that actually she'd rather have some money now. So she goes to sell her reversionary interest on the open market. And the Court of Appeal heard evidence as to the best way of valuing such an interest. And after hearing really quite complicated expert evidence, they decided that it was best valued on a market basis, even though there's a tiny little, almost non-existent market, certainly for domestic property, and that a prudent investor would want the equivalent of a return of 5% above inflation for each year of the claimant's life expectancy. So if Maureen was to live for 50 years, we would take that life expectancy into account, discounting the value of the property for 5% per annum. Now, this leads to the arithmetic, the formula, the algorithm, which in short is get the value of the property. Let's say it's £500,000, and we're going to divide that by the 5% discount, which in mathematics will represent as the number 1.05, and we're going to put that to the power of the life expectancy. And by the power is simply meaning we're multiplying the original number of 1.05 by itself for that number of years. Not that easy to describe orally. Far better if I show you by way of a calculator practical example. And I'm going to share my screen now and bring up, as you'll see, a scientific calculator. And this is going to be useful because, of course, if you'll have this as a standard feature on Windows, but also if you get your iPhone turn on the calculator function, turn it on its side, and you'll see something that's reasonably simple. Now, there's two different ways to do it, but I'm going to suggest that we start off this way. First of all, let's get the value of the house, 500,000. So it's 500,000 net purchase price after the claimant's existing equity in their current house has been taken into account. And what we're then going to do is we're going to divide it. So we go over to the divide function, and then we're going to go to the 1.05, as I said before. And as I said, this is where we bring in the formula that it's 1.05, in other words, the 5% discount rate to the power of the life expectancy, the number of years in which Maureen's expected to live. And we go to this calculation here, this button, and you'll see it on your iPhone, and you'll certainly find it in Windows. So we'll press that, and then we're going to put the life expectancy. Let's suppose Maureen's got 50 years left. 50, press equals, and there we have it. That £43,601.86, ignore the rest of the decimals, is the value of the reversionary interest. So if we're then going for the damages for the capital cost, it's going to be 500,000 minus at 43,601 pounds and 86 pence. And we see that the total that the insurer is going to be paying out is £456,000 odd. So that's how we do the calculation on a standard scientific calculator that we all have access to. So I'll just go through that one more time. We'll go for the value of the house. Let's say this time it's going to be 250,000. The net, that's the net additional cost. We're going to divide that by 1.05. We go to the X and Y button, press it. Let's suppose this time the claimant's going to live for just 10 years. Press equal. And this time, as you see, we have a much larger value for the reversionary interest, just over £150,000. And so the claimant's damages would only be 350,000 in the end. And you'll immediately see that the life expectancy is key to whether this is going to be a large figure or a low figure. But of course that cuts both ways, because of course, as you know, you might, with a long life expectancy, as an insurer, you're going to win on the Swift and Carpenter calculation, but you're going to lose in pretty much everything else. And the reality is, if a claimant is so badly injured that they need special accommodation, then one can imagine that the loss of earnings, the care, the therapies, and everything else are going to also form a substantial part of the claim. Now, I'm going to share my screen again now, because on this occasion, I want to take you to a spreadsheet, which I hope is coming up on screen now. And you're looking at an Excel spreadsheet. I'm formulating a Swift means for a Swift and Carpenter calculation. It's a work in progress. So if you look at this and think, oh, well, I don't like, for example, that betterment or appreciation or depreciation is appearing up here rather than down here, that's okay. We're going to be looking at this more carefully in the days ahead. But what I'm doing is I've included calculations which lets me put in the cost of new accommodation, 500,000. Let's assume that the claimant's got some equity in their existing house. often the case. We'll say 100,000. That's the net cost. I can put in however many years of life expectancy, and that automatically calculates the value of the reversionary interest. And for those of you who are eagle-eyed, you'll see right up to the top of the screen where my Excel formula is. And in this sheet, I've also allowed for modification costs, moving and ancillary costs, and also a way of calculating the annual maintenance that of course is usually present where a claimant's bought a bigger, better, more expensive to maintain, insure, pay council tax for type of property. I use some examples here. Here we have a 60-year-old female claimant who suffered bilateral amputation living in the south of England. Her life expectancy is found as a fact by the court to be 75 due to a lack of mobility, underlying health issues. She's wealthy. She already has a good 6-bedroom home worth £1 million, owned jointly with her husband. So it's going to cost £1.5 million for the new property. Her equity, her share of the equity is 500,000. That means the net cost of the new accommodation is £1 million. Life expectancy here, we're going to say 30 years, and that means the value of the reversionary interest is 231. The damages for the capital cost is 768,622. If we cut, well, that's actually, I've been playing with the figures, that's if it's a life expectancy of 30. On the facts, it should only be 15. But look what this does to the value of the reversionary interest. It increases it very substantially indeed. And that's something Chris Kennedy is going to talk about as to whether the court might modify the approach in such a case. If a life expectancy was only 5 years, look, the value of the reversionary interest is 782. The lady will only achieve £216,000 odd for her damages for the capital cost. Well, even though she and her husband have a house worth £1 million, they're still going to have to dig in to the other damages or their savings in order to fund the new house. So that's a good illustration of why life expectancy makes such a difference. By way of interest, under an old Robertson Johnson calculation with a 2.5% discount rate as it was, the damages would have been 313,500. So more than a 5-year life expectancy, but less than a 10 years and beyond that. Two more examples to look at quickly. Here's for a 13-year-old child with badly broken legs, can't use stairs. Parents live in a £200,000 property, but I suspect that's going to have to be ignored because on the facts, the claimant will be living on her own and she'll probably keep that bungalow and her parents might move out. An argument that in fact it's a better property that she'll need than she will need in the long term. So I'm taking £50,000 off for betterment. Her life expectancy, I'm using an Ogden Table 2 at 0% for a 13-year-old female, 76.8, an astonishing multiplier, of course, with or an astonishing life expectancy nowadays for a young lady to almost to age 90. So it's a 76 life expectancy put in that box, and it means that the value of the reversionary interest is tiny. So on the court's finding, a prudent investor with £10,000 to spend now wouldn't want to pay any more than that to get the reversionary interest for a 13-year-old in the house. And so the deduction is almost meaningless, quite frankly. And the last example is a 33-year-old man in a minimally conscious state, living with his wife, no children. He was renting, and so there was no equity in any property before it starts. And so we see £300,000 for in a much cheaper part of the country, arguably a prettier part of the country. 25 years left. The reversionary interest is 88,000. The damages for the capital cost will be 211,409, and that compares with 139,875 under the old Roberts and Johnson. What's interesting in this sort of case is his life expectancy is 25 years, but suppose after 15 years, the evidence before the court was very strongly to the effect that he would have to move back into hospital accommodation as he was entering his last few years. If that was the case, then the life expectancy wouldn't actually be a very fair measure of the reversionary interest. We should really be using a figure of 15 rather than 25 here, which, as you see, make quite a difference to the damages. That's something that perhaps Chris can look at, but I hope now you'll understand the calculations, see that the sum isn't that tricky, but the variables can lead to quite different results. And so thank you for bearing with me with arithmetic and calculation, and I'm now going to pass over to Chris Kennedy QC.
For that very helpful summary. Matthew asked me to talk about the wider issues raised by Swift, and I've got 7 points that I'd like to draw to your attention arising out of the judgment. The first of those arises from the approach that the judges took. When you come to look at the judgment again, can I invite you to look at paragraph 36, where Lord Justice Irwin said that the court had to ask itself 3 questions. Does Roberts and Johnson apply to the facts of Swift? And they found that the answer to that was yes, it did. And then the 2 supplemental questions are, if so, can we revisit it? And should we revisit it? And it's that first one that is central to the first thing that I would ask you to have a look at. Can we revisit it? And their approach, which ultimately led to the conclusion, yes, we can, was the one for which the appellants argued. They said that Roberts and Johnson amounted to what they called guidance, albeit authoritative appellate guidance, rather than legal principle. And you can see that in paragraph 37, where Lord Justice Irwin summarises that argument. The respondent argues that the court is bound by Roberts and Johnson. The appellant submits not so. Firstly, the approach enunciated in Roberts and Johnson represents guidance rather than the legal principle. Secondly, conditions have changed so as to render that approach unjust in its effect. And what you can also see in the judgment is how keen they were on considering whether or not it was appropriate to adapt principles in earlier judgments to modern circumstances. The first sign of that was in their discussion of one of the cases before Roberts and Johnson, George and Pinnock, which is a 1973 authority. I don't need, for the purposes of this talk, to take you to the facts of George and Pinnock, just what they said about it. What they said in paragraph 39 is, aside from the very simple, not to say approximate approach to personal injury damages, redolent of the time, the clear implication is that was then, but this, Swift, is now. What they were doing is acceding to a submission which was made in the case of Snarr and the Ministry of Justice by Frank Burton that you can revisit certain types of judgment, although in that case, that submission was rejected. So it has its problems. In Nower, the Supreme Court decided that what they had to do was use their powers under the Act to overrule one of their earlier authorities. The obvious problem is that one person's guidance is another person's statement of principle, and you are going to have a whole host of arguments about what the status of various pronouncements are. But the court, it seems to me, was persuaded that this was a route that they should go down for a reason that Brian referred to in his section of this particular talk, which is the particular circumstances that we as personal injury practitioners do our work under. And that is that so much of our work, as they said, perhaps more than in any other field of litigation, disputes are resolved by negotiation and settlement, so that there needs to be clear guidance from an authority as to what the approach should be to that negotiation and that settlement. But times do move on. And in the passage after the passage in paragraph 78 that Brian referred you to, the court went on. Yet the nature of adjudication of compensation, perhaps most critically future losses, if it is to amount to anything more accurate than the frankly crude approach adopted many years ago, requires close attention to many changing circumstances. So it's nice, we can feel special. Our field gets treatment that other areas of the law don't. But it does raise a question, and it's a question that I suggest we all need to think about. If this particular long established rule can be seen as merely guidance, how many of the other old certainties are ripe for the same treatment? And are we about to enter a new age of judicial intervention in what we thought were clear and long established principles? Well, the Court of Appeal did try to say, no, that's not what's going to happen. And I refer you in particular to paragraph 79, where they made it very clear that as far as they were concerned, it is only for appellate courts to give guidance of this kind rather than first instance courts. But that again has its own problems because, for instance, the High Court is both an appellate court and a court of first instance. So what does one do if there is a High Court authority giving guidance and you're in a High Court case at first instance? I don't know. But you should be aware that you don't have to think very hard for other authorities in which this kind of approach to Robertson Johnson may be transposed. I can give you two more or less straight off the top of my head. What about Housecroft and Burnett, the rule that gratuitous care claims should have a 25% deduction from them? Is that something that needs revisiting on the basis that it was only guidance? What about the fact that you can't have any claims for services in lost years, which is the effect of Phillips and Brooks Dry Cleaning Services, a 1996 authority? Is that something that was merely guidance and can now be revisited by another court of appeal? It does look as if there may be fertile territory for all of us barristers and solicitors out there, and rather depressing news for insurers having to pay us, but there we are. All litigation is good litigation, you may think, or not, I don't know. That's the first point, and I think the most important point in terms of the wider approach, that there is scope for the swift jurisprudence to be applied in other areas relating to personal injury. The second point is rather narrower, and it's about the relative merits of the solutions proposed by both sides. Aside from some bad luck, which the respondents undoubtedly had because COVID forced a material section of their expert evidence to have to be recast, and that forensically didn't look very good. There was another problem that was there from the start, which was that the respondent's solution was complicated and was going to call for expert evidence. And you can see in the judgment that its complexity made it a more difficult sell for those advocating it. And it's a reminder that simplicity and predictability are important and are things that do commend themselves to appellate courts in this kind of situation. That's my second point. My third point, you may think is obvious, but it needs restating. This was a case about the relative dangers of undercompensation and overcompensation. You had a claimant who needed a house, but giving that claimant the full value of the house would give that claimant more damages than in justice they were entitled to, because the asset has a value beyond their life. What is quite clear from the judgment in Swift is that undercompensation and overcompensation are not seen as equal risks by the Court of Appeal. There is some, I wouldn't say lip service, although that was the word that was on my tongue, that there is some respect paid to the proposition that the goal is fair compensation, to use Lady Hale's words, not a penny more, not a penny less. But it is equally clear from all the judgments that if there is a choice between undercompensation and overcompensation, then overcompensation wins, because by overcompensating, you achieve fair compensation. And you can see that in Lord Justice Irwin's judgment at paragraphs 127 and 124, 146, where he says in particular, I recognise the need to avoid a windfall to the claimant's estate, if that can be achieved without prejudice to the cardinal principle of fair and reasonable compensation. So fair and reasonable compensation first, even if that means overcompensation. If there is a way of avoiding overcompensation without making it unfair and unreasonable, then yes. The next point, point 4, that I would draw to your attention is that this is another occasion where Table 28 has beaten Table 2. The fixed term multipliers in Table 28 were preferred by the Court of Appeal, as they often are in life expectancy cases, to the whole life multipliers, which tend to produce a lower result. I wasn't there to listen to the evidence itself, and Lord Justice Irwin, in a masterpiece of understatement, says, well, we've made that decision for technical reasons, and then doesn't go any further. The argument, it seems, that was in fact accepted is that all the uncertainties that the respondents wanted addressed by going back to Table 2 and the lower figures were factored in the judgment itself, and therefore it was appropriate to use Table 28. It's part of what I see as a growing trend towards Table 28 over Table 2 for these kind of calculations. Well, there is one set of cases that have explicitly not been dealt with in the judgment, and they form my point 5. And they're short life expectancy cases. You need to know where the paragraph is if you have one of those cases. It's paragraph 171, where Lord Justice Irwin ends by saying, it may be that different considerations and arguments could be applied to that category of case. I make no further comment on that and should not be understood to express a view about it. And the reason for it is that, as anyone who's had one of these cases will know, they do produce very different problems, because you have the need for the house, but if you have someone with a relatively short life expectancy, the chances are that there isn't going to be a lot of money elsewhere in the claim in order to produce the capital to make up the shortfall. So if you have, for instance, an 80-year-old tetraplegic who needs alternative accommodation, he's not going to have a loss of earnings claim. All of his money that he needs for his care is actually going to be used for his care. He doesn't have massive equipment needs because it's basically one of everything, and he needs those ones of everything. So where is the money to buy the house if it isn't in a full capital value? And you may think that what Lord Justice Irwin is doing there is putting the ball into the defendants and the insurers' courts to come up with a solution. Because if they don't come up with a solution to these cases, then you are going to end up with a situation where in the cases where the reversionary interest is at its highest, the loss is going to be the greatest, because the court is going to say, well, I know it's overcompensation, but he needs a house. What are we going to do about it? So that's important. It does tie into a challenge that Brian set me, which is, what about cases where you can say as a matter of certainty that the use of the house will end at a particular point? Now, in that hypothetical assumption, I can see the argument for saying, well, that's equivalent to a short life expectancy case where the guidance in SWIFT does not apply. I have to say that it would have to be a pretty strong case for that to have for that to be persuasive, because the whole point of guidance of this sort is to take a bit of the rough with the smooth. But in a clear case, there must be, in my view, scope for arguing that the particular facts take it outside SWIFT, as the particular facts in short life expectancy cases may take the case outside SWIFT. My sixth point concerns the 5%. 5% has been set at the discount rate, but it is to remind you that the door is left open to revisit 5% if the evidence justifies it. And there's a recognition that 5% is a cautious figure. It was the lowest figure in the evidence of the relevant expert, Mr. Watson. So it may be that there is scope for a challenge to that in future years if a body of evidence can be accumulated. I want to end the points that I've taken from SWIFT, from the wider implications of SWIFT, with what I could see was the only substantial area of disagreement between the judges. And again, it goes back to something that Brian was talking about. It's this difficult question of whether you are entitled to say that a claimant can be expected to use other heads of loss to finance accommodation or indeed anything else. Lord Justice Irwin was very clear about that in paragraph 144 of the judgment, where he said, "For the avoidance of doubt, there is, in my view, no proper basis for requiring a claimant to invest damages awarded under a discrete head, such as future loss of earnings, in the purchase of property." Well, Lord Justice Underhill wasn't quite so sure. He said, and this is paragraph 225, "I should add that I'm not sure that it would even be open to us as a matter of authority to hold that robbing Peter to pay Paul, in that sense, is wrong in principle. As Mrs. Justice Lambert points out in the passage already referred to, a degree of scavenging from damages allocated to other losses was inherent in Roberts and Johnson from the start." And he then discusses the question of whether they're free to depart from Roberts and Johnson before concluding paragraph 25 by saying, "It is debatable whether that justifies us in going behind the court's assumption, which was necessary to its reasoning, that it was acceptable for the plaintiff to have to fund the capital cost of the accommodation out of other elements in the damages." So that's a debate that hasn't been resolved by SWIFT. and will continue, it seems to me, to exercise practitioners and insurers alike. There are 4 points on which perhaps I should say something before I conclude. The first is the question of whether or not there is a point of general public importance in this case, which will justify an appeal to the Supreme Court. I don't know what the thinking is on that. I have no insight into that whatsoever. Certainly, the issue of how to approach cases of this sort does, it seem to me, raise issues that could be taken further, but whether they will be, as I say, I can't say. There are, however, practical implications for accommodation claims. First and most obviously, as Brian has demonstrated in his excellent tour through the spreadsheets, the capital cost of accommodation claims is going to go up, and this will affect the reserves that need to be allocated to this particular head. And that doesn't just affect the general reserve, and this is my second point, it also affects interim payment applications, because of course capital costs for accommodation go into EALS 1, so you immediately get a bigger EALS 1 number in cases which have an accommodation element. And that leads to my final point, which is that our accommodation experts have suddenly become more important. Not only are they more important and need to produce more detailed and more forensic reports, but those reports are likely to be needed much earlier in the litigation, and we're going to need to answer more questions about where accommodation fits in at that earlier stage than has hitherto been the case. So thank you very much for your time. I'm going to hand back to Matthew, if you're still with us, of course, and he will conclude this particular webinar.
Thank you, Chris. I'm going to try and summarise some of the fantastic content we've had, both from Chris and Brian's talks. I think really the 2 points that have come over from particularly Brian's talk is, as Chris has already just stated, the costs are going up. And for those of you that were watching carefully, you will have seen Brian's spreadsheet formula for the appropriate calculation, and I hope that was worth the admission price alone. The second point Brian makes and Chris draws upon is that life expectancy is important. Short life cases will continue to be problematic and will need to be dealt with on a case-by-case basis. The point Chris raises is whether the ball is now in the defendant's court to come up with a solution. It is, of course, most important to look at the formula and the way in which these cases are now going to be calculated. But some of the jurisprudence from SWIFT may have an effect which lasts for a long time. Chris's point, or rather his question, about whether the jurisprudence in SWIFT has heralded a new age of judicial intervention between cases that were long thought to establish legal principle may now be held simply to be matters of guidance, and we will watch that area with particular care. I think also, lastly, to impress the point of the primary principle of damages in tortious cases, to ensure that compensation is fair and reasonable. This case is clearly reaffirming that principle and demonstrating that it will trump what is referred as a secondary principle to avoid overcompensation. And again, that may have more long-term ramifications in the future. Thank you for joining us today. If you have any further queries, you can contact our clerks or you can contact us directly by email, which you will find from our profiles on our website at www.9sjs.com.